My lady, I was addressing you on the existing bail bond terms,
Yes, you are.
and I had indicated that the second bond term that is existing is that the accused persons do not in any way interfere with the witnesses or tamper with evidence.
Yes.
The third condition, my lady, that you imposed on the accused person was that they do not involve themselves in crime. And my lady, the fourth condition you imposed was that they do not visit the scene where the alleged crimes happened, particularly Nyalenda, Obunga, Nyawita, and Nyamasaria. My lady, it's the submissions of the Ipoa that when you retire to consider granting pay, you have these conditions retained and maintained by the accused persons. And in addition,
just a minute, the places were, kindly name them for me again.
Nyalenda.
Yes.
Obunga. Nyawita. And Nyamasaria, which are in Kisumu. My lady, these are the places we identified in your order, which is dated the 12th of May, 2025.
Yes.
And my lady, we are submitting that we have the same conditions maintained where the accused persons to be released on granted bail. And in addition, that my lady, you impose a condition that the accused persons, whether by themselves or proxies, do not disclose the contact details of the victims and or witnesses whose detail they may be in possession of by the virtue of having been served with the information that had disclosed their details before the information was redacted. My lady, in addition to the areas that the accused person should be restricted from visiting, we urge you to consider imposing a condition that they also do not visit Kondele area. My lady, we also humbly urge you that you consider ordering the accused persons to deposit bail in court with suitable sureties and this is my lady to enhance their commitment to appear in court for trial as and when required. My lady, we are sorry.
Go ahead, I can hear you.
My lady, we are also praying that
Yes.
a condition be put that the accused persons deposit their travel documents with the court or in the alternative, that my lady, they be informing court whenever they intend to travel outside the country. And my lady, we are submitting on that, taking cognizance.
Counsel.
Yes.
The ruling on bail is being written by counsel from Ipoa. In fact, at the end, I only need to put my signature. Yeah? Anyway, you are all entitled to address the court. The last part I didn't get, kindly repeat it. You also pray that the accused persons deposit their travel documents in court.
Yes.
Then you say alternatively. From there, I didn't hear.
Yes, in the alternative, that they be informing the court whenever they inform the court and they seek the court's authority whenever they intend to travel outside the country. And my lady, we bring out this issue because we've realized in the bail report, particularly for the second accused person,
Yes.
she has family ties with persons outside the country. And in that case, she might feel the need to travel. Lastly, my lady, it's a humble request from Ipoa that the accused persons report to the Ipoa offices nearest to them once every 3 months until the conclusion of the prosecution case.
The seriousness of the offense, first of its kind in the Republic of Kenya. And that offense places the accused persons as commanders, not subordinates. The subordinates are not in court, not been charged. They are still serving police officers. With access to the scenes of crime, with access to the potential victims and witnesses. the ones under whose command the accused persons were working. So when faced with such a serious offense and its nature presents a web that has structures not just in Kisumu, but also in Nairobi and in any part of the country. Then this Honorable Court must ask itself, how best can I limit the question of interference with witnesses? Is it a case where the court should consider denying bail or bond? Especially for the 4 who are still actively senior police officers. The 3. And my lady, we cannot turn a blind eye. And I invite the court to take judicial notice of recent events relating to deaths in police cells.
I knew that is where you are headed. Please, with all due respect.
I have to go there.
Wait. Allow me. You always tell us we are bound by what is presented in court. Kindly let us focus on case number E074 of 2022. I will say no more.
My lady, without going deep into it, but I just want to say one thing. That these are police officers not denied. And my lady, I am constrained if the court asks me not to make a commentary on conduct of a police service.
No. You say the reason.
You have already made a decision on that.
Please.
I'm still talking, please.
Please, Council. These proceedings are recorded and we can get a transcription of me saying, let us focus on the matter at hand. I have recorded your issues regarding opposition of bail and bond.
Yes.
A, B, and C. The minute you veer off case number E074 of 2022, it is my duty to say, unfortunately, I cannot determine any other issue apart from criminal case E074 of 2022.
I am guided, my lady.
Thank you.
I will not veer off.
Thank you.
But I will just backtrack the point that the remaining 3 accused persons minus the one who is retiring are senior police officers as confirmed in the probation report. And to them, charged as commanders of police units, are still in command of those units. And their subordinates spread across the entire country are answerable to them. So even when the Honorable Court says they cannot step in Kisumu, parts of Kisumu, a term and a condition which is welcome, we must still invite the court to consider what was the objective of that term. It was to deny them an opportunity to potentially interfere with witnesses. And I am now bringing to the attention of the court, charged as commanders whose subordinates have tentacles across the entire country. Those tentacles can still interfere with witnesses at their behest. So it behooves the court to consider a restricted approach on the question of bail or bond, to limit the ability to exercise their command. Because they are still commanders. It will be a mockery of the criminal justice system if you charge a commander, release them to go out, and they still maintain command of their units. That is what I'm asking the court to consider. This is a first of its kind. They are not charged for other offenses like stealing, theft. They are charged on the basis of being commanders. Can they continue to be commanders of those units when the trial is taking place? Without according an opportunity of interfering witnesses. We do pray, my lady, that the terms that were initially issued were not bail and bond terms issued upon charging. Those were merely terms when we were still doing the preliminaries. The charge sheet had not been registered in this court. At that time, they were just called suspects. There was no question. I know. All your IT experts are. At that point, my lady, when the initial terms and cognizance was given by the court, what the court had before it were suspects. There was no charge sheet registered. There was no accused person. The status of the 4 accused persons changed from being suspects to accused persons when the charges were read. The severity of them made known to them, and the criminal trial process began. At that point, the court, I don't know if my ladies can hear us. It's them, it's the state. My lady, I don't know if you heard my. Oh, there is, you allow us to stop conclude. My lady, I don't know at what point we lost you.
Your decibels are so high.
It is not me dismissing, interfering with the network.
When I'm lost, I always say, kindly just tell me what you said at this point. You've not heard me speak.
My lady, it was the network. The network.
Go on, cancel, go on.
No, just the last point. The last point, my lady. What you last heard, my lady, because the system had.
I'm not saying what I have had. I'll have this file before the DR. You can peruse.
Continue, my lady.
Continue. Yes.
So,
yes.
My lady, when the accused persons were admitted to take plea, their status changed from suspects, and the severity of the charges they were facing was made known to them. When the initial terms were issued, they were not accused persons, they were just suspects proposed to be charged. Now, the formal criminal trial process has begun. Their status has changed, and they are still commanders of police units, charged as commanders. The Honorable Court should consider, especially for the 3 minus the 1 retiring, if this should not be an appropriate case to admit to conduct the trial with the accused persons in custody, to limit opportunity of them or their subordinates interfering with witnesses.